A huge portion of the U.S. economy is made up of small businesses that have securities that are unregistered. Welcome to Alt Investing Made Easy, where we explore the complex world of alternative assets. I'm Roland, a securities attorney, investment advisor, and your co-host.
And I'm Sarah, an investment advisor and corporate attorney, and your other co-host. We'll guide you through real estate, private equity, and more, making complex topics accessible.
Tune in for insights that empower your financial journey.
Let's make alt investing easy, one episode at a time.
Welcome everyone to Alt Investing Made Easy. Today we're going to take a deep dive into a subject matter we covered in our first episode, Intro to Alternative Assets. Today's topic is an overview of the regulatory framework. We hope you find this level of detail interesting and useful. Roland, do you want to take it forward and introduce the terminology?
Yeah, for sure. And the main regulatory framework we're talking about here is, the statutes and rules. And we always have to start with the U.S. federal law that governs securities transactions and offers of securities. And the statute that we deal with the most is the U.S. Federal Securities Act of 1933, which basically says that any securities that are sold, this is stock in a company or a limited partnership interest in a limited partnership or a membership interest in LLC, any security any of those or any other kind have to be registered before they can be sold. And the registration process is long and onerous, and we can talk more about that in a second. But that's the general rule. And that's a U.S. federal law, so it applies everywhere. And all the states basically follow that rule. It's just requiring all securities to be registered. And fortunately, though, we work with some exemptions that allow for much less costly in terms of the legal fees that you're going to pay. It's much less costly to offer private securities versus a fully registered securities offering. And so that's the high level. The Securities Act of 1933, it's a U.S. federal statute, and 1933 is the year that it was enacted, shortly after the beginning of the Great Depression in 1929.
And that's just to reiterate what you're saying, Roland, because it's such an important concept that people need to understand. And that is that the rule is that all securities are registered. The exceptions to the rule is where private securities fall, and that's where all of the work that we do lies for the most part. And it's just important to remind people that there is an exception that permits all of these private securities. It's not an entitlement in the same sense. The rule is that you have to register. So, and there were really good reasons for all of that, and there remain really good reasons for all of that, which is essentially to protect investors. So,
just if we could pause there for a second, because I think that people don't really appreciate, mostly when they think about securities, they think about I know I always refer back to the evening news, and I guess it still is a thing, and maybe most people do get their news from TV, but the securities that they talk about on TV are generally registered securities. They're public securities. But the important thing to remember here is this is a statistic that we probably could look up at some point, Sarah, is like the relative size of the private companies versus public companies in the U.S. But we're really talking about small business, and some of these are very large small businesses, but it's, a huge portion of the U.S. economy is made up of small businesses that have securities that are unregistered. And so that's what we're talking about. These are mostly companies that you'll never hear about on the news.
Right.
And it's the small businesses that you could think of, throughout the United States, the ones that you interact with on a daily basis. They're companies who did not register their securities pursuant to these exemptions that we're going to be talking about.
Right. And this is again, we've mentioned it many times before, is part of the democratization of capital here. And that is that to have a healthy and vibrant economy that's stable throughout all different levels, you need to have an ability for small businesses to start, to raise money, to have people invest in them. They grow to small mediums, they grow to mediums, they go to medium large, they grow to large, right? And all of that is supported by the regulatory framework that we're talking about today. And it was really the first system in the world to establish such a regulatory framework in the United States. A lot of other countries have modeled and improved, one might say, the whole framework in the details, but the concepts remain the same, which is you got to protect people from the really large, in respect of the really large public equities, and you got to also protect people everywhere else that you can. But there are some exceptions that, subject to certain rules, allow a lot of activity in the beginning and early beginning and middle stages of a company's life. And I think arguably, it's kind of, you can see some of these really large private companies that probably started small. It's the same. This illustrates this process, right? That some of the really large private companies out there who never did go through the public equity route, they got started. Perhaps some of them had more initial capital than others, but they, in theory, in principle, the idea is that they started small and then built. So.
Yeah, and it's so common, and I think there's just general. We're filming today, March 12th, 2025, and I think there's a lot of skepticism about the government, particularly the federal government right now. But when we step back and have a conversation like this and talking about our securities laws, and particularly, Sarah, I mean, talking with you about all your knowledge about doing business abroad in the Middle East and Europe and UK and other jurisdictions. Just how thankful I am. I practice in this area of securities law, and I know a lot about it, but I'm the beneficiary of it living here in the United States. And we had a government, at least back in the 30s when they were enacting these laws, that it's like what Sarah said before, they were consumer protection laws to prevent fraud. But then also there was this knowledge that we need to encourage small business as well. And so as they've evolved over time, and particularly with Reg D, and that's another topic that we need to come up with, is kind of the history of Reg D.
I think it's on our list.
Yeah. But I mean, I think that was in the 80s when that really came about, and it's actually developed further, but it's really enabled American small business. And this topic that Sarah brought up, democratization of capital, which I love. We really do live in a country that has enacted laws to enable small business. It may not seem like it, but we are able to do things in the United States that you just simply cannot do in other jurisdictions, do them in a way that's really relatively inexpensive. And that's one of our goals as attorneys, is always trying to help our clients do things as simply and as inexpensively as possible.
Exactly. So you mentioned Reg D. Let's talk about Regulation D.
Yeah.
Regulation D might... Oh, sorry. Go ahead.
No, I interrupted you.
Well, Regulation D might be the one that our clients at least seem to be able to quote back to us the most, in the sense of they've heard of it, and they know that it's important in private deals. And the reason, of course, being that that's where we have Rule 506B and Rule 506C. And those are two of the main avenues for or exceptions to having to register your securities. And they set out a way that you can qualify and otherwise promote your private securities.
Yeah, and this is another statistic that the precise numbers would be good, but it's in excess of close to 95% of private offerings of securities rely on Regulation D. And so that's a huge number. And I don't know, I've never done an offering other than, I've worked on some IPOs, which are, the registration process, but all the other offerings that I've ever done my entire 27-year career since the last century is under Regulation D. And so it's just very widely used. And The good thing about Regulation D is that there's a federal preemption, which means that it's a federal law, and so the states can't enact any law that contradicts it. It's basically the U.S. federal government coming in and saying we have this overriding interest in the securities markets being really regulated and safe, and so we're going to preempt anything that the states would do themselves. And the states do still have their own securities laws, but they're with respect to more state exemptions that don't have the correspondence with Regulation D. So that's one thing to note here. Try to describe, it's complicated, but the interaction between the federal and the state securities regulation regimes.
And I thought you did a good job of that, Roland. I would just add, just to re-emphasize the importance of what Roland just said, and that is that if you did not have this override for Reg D, you would find yourself in an environment trying to raise capital as a promoter, or even if you want to invest in different things, the costs would go up for participating in investment, promoting an investment, because you would have to understand in great detail the laws from whence come each one of your investors. So you need to already you need to know what states they come from, but you wouldn't be able to just leave it at that. You would actually have to understand a lot more level of detail than just knowing what state your investors are coming for. So imagine that you raised capital and you've got a $5 million investor interested from a different state. Then you have to spend the money to understand the laws there if you didn't have a federal override. So I just wanted to emphasize that point, because I think that the way our country is structured is that there is a time and a place for federal law to supersede certain state rights, and this is one of them. And there's very good reason that everybody benefits from.
Yeah, efficiency and safety of the securities markets.
Exactly, which means protecting people from losing their money.
But then also, the efficiency aspect of it, we don't want to so overburden it, make it so safe with all these regulations that it becomes impossibly expensive to comply with all the regulations. So there's a really good balance, I think. And, just going on here in our outline, the idea, excuse me, the consumer protection aspect of these securities laws. And when we're talking about private offerings under Regulation D, we're primarily talking about investment opportunities that are only available to a class of investors known as accredited investors. And very generally speaking, these are wealthier investors that have a high net wealth or net worth, or make sufficiently high income. And the idea is a couple things. They can bear the risk of loss, so they're not investing their last $10,000 in these deals that we're working on. If they lose it, it's sad, but in the end, they'll still be able to meet all their needs with other resources, their income or other sources of wealth. But the consumer protection aspect of it is that you think that wealthier people have more resources to enforce their rights if somebody breaches an agreement with them. They can go out and hire attorneys to sue if they have to, if somebody's trying to commit fraud or not meeting the obligations under the contracts they sign. So really what we're talking about, these investments in private securities are primarily available for accredited investors who are generally wealthier investors. And there's a reason for that again, and it's the consumer protection and just a presumption that, if you're wealthier, then you should be able to look out for yourself, so to speak.
Right. And we've discussed this at length in other episodes, and but part of the journey here is your wealth building, from even if it's from the very beginning to having something. And we've heard this story from a number of our clients, and that is that you start, doing everything you can to save, maybe rely on the super safe parts of the equity markets, that kind of thing, to build up so that you get to a place where you can start to, where you are an accredited investor. And the earlier that you start, the better. And it's entirely possible. There's so many people from all different backgrounds, all different histories, all different situations out there who have started their journey and come into the alternative and alternative investment arena as an accredited investor. And it's really inspiring, and it's so fundamentally important, I think, to communicate that this is a journey that can be done by anyone. It takes a lot of focus and and knowledge. So one thing we're trying to do is help you out there, if you're watching, understand the framework a little bit. So actually, we kind of discussed state laws a little bit, but they're famously known as blue sky laws. I suppose the blue sky is, the famous type of phrase for dreaming, about something that may not work out.
Yeah, I mean, that's what a lot of our clients are selling, really. When you're selling financial projections, it's just what you anticipate happening in the future. And ideally skies are blue, but, that's for sure where that term comes from.
So, and I guess we already touched on some of the topics. What do you think, Roland? You want to add anything? I learned something interesting recently. Let's see if I can. So one thing, just as a little bit of an aside for a little bit of detail about lawyers or laws, the states work together to try and also uniform their state laws to a certain extent in a lot of different areas. There are organizations in the legal community that promote development of uniform laws, and there's a law out there. It's a uniform act called the Uniform Securities Act. This is what a lot of the blue sky laws now are based on. They'll be different from state to state, but small differences. But of course, that's that's written down as the USA Act, which I thought was actually very helpful in remembering the name of that particular Uniform Securities Act. But that's one way that the states do try to work together on the state law level to have some uniformity. And of course, again, as we have noted, that the federal laws here would override. So moving on, private placement. Private placement's a great term because it's used very loosely, I think.
Yeah. We talk about representing people that are either selling or investing in private securities, and a private placement, I guess it's private because it's not public.
Right.
It used to be that you could only make offers on a private basis, I think is probably where it really came from. And what that meant is you could only, if I had a company and I was looking for investment dollars, I could only go and try to sell that investment to people that I actually personally knew, had some kind of pre-existing substantive relationship with, that I knew that person wouldn't be investing their last $10,000. So the markets really have changed, and particularly in response to changing the law in 2013. And it's really the whole reason why we're sitting here is we're able to have a podcast like Alt Investing Made Easy because of a new exemption to the broker-dealer rules that was enacted in 2013 in the Jobs Act. Then also the exemption 506 was split into B and C. B is the old school Reg D exemption, but 506C is new in the sense that it allows you to use general solicitation in connection with the sale of private securities. And that general solicitation is, the public advertisements. And again, the contrasting private placement with, public. So that's one thing that I think is worth noting, that, historically, these private securities deals have been referred to as private placements, but that's not necessarily, an applicable term anymore, maybe.
Right. And it's interesting. I remember when I first started my career, I worked on a big IPO and it failed, honestly, and nobody bought it. The underwriters rejected it, essentially. But what they did instead was turn it into a private placement. And I think in those days, that would have been pre-2013. That was normally what you did. And what a private placement meant was probably just anything that wasn't IPO. in the context of the way the legal team I was on looked at it. So if you wanted to dig into the details under American securities law, it's interesting because this wasn't in the United States when these offerings were governed by a different legal system. But yeah, the term private placement, IPO private placement was still there. And perhaps that's just a legacy of the American securities laws being the fundamental backbone of a lot of securities laws in the rest of the world.
Yeah, and I think that's what they called it really before Regulation D. And again, Regulation D was in the 80s, I think.
Well, it lives with us today in our PPM, right?
Yeah, private placement memorandum for sure. That's what they're called.
Yeah. So in any event, let's see. I think that covers a lot of specific terminology. We could discuss a little bit more disclosure requirements. Because there are certain specific phrases and terminology that come up in that context, right?
Yeah, this is like one of those areas that it really, I always ponder over it, honestly, because there's this term material. And, we as attorneys love the English language, whatever language that you're speaking in, just language as a tool. And words, have entered my lexicon over the years, and materiality, material really is something that I think about a lot, because this is your fundamental disclosure obligation with respect to any security, is to disclose all the material risks to investors that they need to know about. All the material risks that an investor needs to take into account when they're making an investment decision. And also the company can't fail to disclose anything, where the failure to disclose is material. And so that, what is material? I'll have to talk about one of my mentors, and I asked him that question. I was a couple years into my practice about 20 years ago. And I said, well, I'll name him Daryl. Daryl, what is material? And he said there's no precise definition, but broadly speaking, you can maybe Daryl, I hope I'm quoting you correctly, but this is sort of what I remember, that you think about 10% of an amount is for sure material. So like if we are a company that makes $100 million a year, and we're going to experience some loss that's $10 million, then that $10 million represents 10% of our earnings for that year. And you would have to say that that's material. Mm-hmm. If it's $1, they had the bank had to refund somebody an ATM charge of $2. Well, that's not material. But if they erroneously charge, over the course of a year, however many transactions, some huge number times the $1 ATM charge, that for sure could become material. So material information, you have to make sure that you're telling investors anything that they need to know about the company that they need to know to make their investment decision. And you don't need to tell them that you got a 10% coupon off at the paint store for rehabbing a multifamily property. But, if there's a fire that destroys a quarter of the units, for sure, that's a material bit of information that an investor would want to know.
And I think also, just to add to that, because materiality is a favorite lawyer word. And if you have a friend who throws the word material into their conversation, you got to ask him, are you a lawyer? Because probably nobody else uses that word. But it is a catch-all word for such an important area, which is this fact that you can't precisely detail one word that describes when something's important, because it's the facts and circumstances. So, in the ATM case, if you're overcharged $2 every month for a year and you normally run $1 million through that account, that is not material for you. But if you are running, or you earn $1,000 a month, that could become material for you. That could be, by the end of the year, $25 or something that you could do something else with besides just let it go to the bank when they shouldn't have had it. So that's another aspect of materiality, right? And assessing whether something's material. It's the situation in front of you, the facts of those circumstances, and what is essentially kind of important in those circumstances. Okay, kind of important is also very vague, but I said that for a reason, which is what's important. Again, in a commercial real estate deal, it's not really important if the pink paint was cheaper than the peach paint, other than your preferences, right? But it is important if you don't paint, right? Because that would impact the ability to rent out the units in the first place. So
that's a great way to describe it.
A material situation that you need to, address, and then whether it's a disclosure point or not is a separate investigation or assessment.
I've told our clients this before, that, put yourself in the investor's shoes and ask yourself, is this information that I would want to know?
Yeah.
As an investor. And if they say, well, yeah, they would. And if they knew about it, it would make them not want to invest. And I would say, well, yeah, I mean, that's exactly why you actually read these PPMs that we draft, and it sounds like we're trying to talk the investors out of making the investment actually, but we're really not. We're just trying to make sure that they understand that there are some risks associated with their investment that, aren't the same types of risks that they have when they invest in all these securities that everybody knows about, the ones that we hear about in the news, and those are public securities. And the biggest risk is liquidity factors.
So, and definitely this is why we talk about risk so much here, right? Is because it's part of your disclosure requirement. It's part of, it's material information that is, an investor who, however sophisticated you are, if you're investing in a new type of asset class, you may not know automatically the kinds of risks that you should be thinking about. The general ones, perhaps. So it's incumbent on the promoter of the deal to be forthcoming about the risks that they see, and to be, honest about that, first of all. And in the end, it does sort of start to read sometimes like somebody who's extremely anxious and can't stop worrying about every little thing. But in the end, this is useful information, because, another thing, just to make a point about when you ask about materiality, it's one of those things also, I think, that you have to be balanced about. Like, you may be a micromanager type of a personality and every detail is material to you, because that is how you assuage your anxiety or your fears or your risk aversion. Other people, but that also is not actually what materiality is, right? You don't get just to pick and choose and say, I want to know every detail of every choice that you make on every day, because that impairs the success of the investment as a whole for all the investors. So again, that's why material is not specifically defined in any one way or another. It's not like if it's 10% of the budget, it's material, or if it's 3%, it's not, right? It could be different in every situation. And you have to manage all of this.
A 3% amount could be, material. So
it could be a lot of money, right? If it's a large project, or if it's a small project, it could even be, a cost of 3% change could really impact on whether a project could be successful. So it's a very interesting area. And I suppose, Roland, it's one reason why the world has lawyers.
Yeah, exactly. And the other thing, whenever materiality comes up, it's the reasonable investor. It's what a reasonable investor would want. Well, what's reasonable? It's an equally, that cannot be defined with precision. But it's just, your everyman investor who maybe you should assume is a little less intelligent than you, or for sure less knowledgeable about it. So kind of putting yourself in the average Joe's shoes and saying, well, this guy is just wandering in off the street and trying to learn about my business. So I really need to educate him and make sure he understands everything here. And this is the other thing that I think our clients sometimes they need help understanding, is that from their perspective, if you're a deal sponsor, the disclosure that you provide is your friend, because the biggest risk is an investor coming back later on and saying, hey, Mr. Deal Sponsor, you didn't tell me about this. I thought you were going to be investing in something else, or, you didn't tell me that this was potential risk that could happen. And what we always tell them is, prepare the offering memorandum because you want to be able to pull it out and say, well, look here on page 12, I told you we were investing in this specifically. And here on page 20, I told you about this specific risk that could happen. And, that's what happened. That's what caused the loss. So, disclosure in the PPM for our deal sponsor clients is a guard for them. It's a shield that hopefully they'll never have to use. But if a loss occurs, then they want to be able to pull that out and be able to tell their investors that they inform their investors of all the material information that the investors needed to make their decision.
Right. And you know what else, just to add one other point to that, because I've been on the inside of a big business preparing a PPM, and that is that it forces you, whatever size deal you're talking about, it forces you as the sponsor to fundamentally spend time considering every possible risk that you, in all reality, you may not have considered all of those. You may see a draft PPM from a lawyer and be like, oh, thank you for making me think about that. All of that is to your benefit. The more you pre-contemplate potential things that can happen, you're not going to manifest them. It's just that it's all knowledge, and the end knowledge can be, power in that sense. And so I think the process of preparing a PPM is a very educational process especially for investors or people that are starting out to promote deals. And I know that some of our clients who come back with the best questions are the ones who've actually really spent the most time sitting with the PPM for their deal and, had good feedback and things like that. And it's really rewarding to see that happen.
Yeah, for sure. I mean, we like to represent clients that think deeply and carefully about what it is that they're doing, because those are the ones that are successful. And as attorneys, when we represent unsuccessful clients, those are the ones that are at risk of being sued. And if the client gets sued, then they may look at us for somebody else to blame. And so we really do, we have a self-interest in, generally people doing what they're supposed to be doing and encouraging them that. I think we have an ethical duty as attorneys to do that, but it's it's in our self-interest to make sure that our clients don't get sued because, we may be next.
Right. Well, I think that was a pretty good journey through some really key terminology. And also at the same time, we did a deep dive into these concepts that we've talked about in relation to the regulatory framework for private securities in detail, which is in line with what we're trying to achieve with this deep dive. Do you want to add anything, or you think that's a good time to wrap it up?
Yeah, I think it is a good time, coming up on the 30-minute mark. And I guess the only thing I'd add in, Sarah, is just our standard disclaimer that while Sarah and I are both attorneys, Sarah's registered in multiple jurisdictions. I'm just registered in Texas, but we can't give legal advice to this podcast without an actual client engagement with you, because we just don't know your circumstances. But we're trying to provide education here generally that applies to everybody. And we also can't give investment advice without a specific investment advisory arrangement with our audience members. So we do love to talk to people. We talk to people all the time, and we just note that we're practicing attorneys. If you have any questions or want to discuss any of the topics that we talked about today or on any other episode of AIM, Sarah and I are available for free consultations, and our contact information is in the show notes.
That's right. Exactly. And as you can tell, we're both very passionate about this subject. So we like talking to people, and we also really like supporting our clients with all of their deals and watching them be successful. So thank you for watching, everyone. If you enjoyed watching this video podcast from Alt Investing Made Easy, please like and subscribe and follow our channel.
And remember, everyone, take AIM with your alternative investing strategies.
See you next time.